you need to make sure that you have all the formalities. So every state in the U.S. has what they call intestacy laws, and then they have what you might imagine are testacy laws, right? Which are laws about wills. Statutory, from the legal perspective, what is required. So there are some jurisdictions where you can have what's called a holographic will, meaning you can actually write it. You can write it in your own hand, and if it's written in your own handwriting and has a date and says that it is my intention that this is my last will and testament, right, like what you've seen in the movies, and then you sign it. In jurisdictions where holographic wills are valid, that would be valid. And then what would happen is, at your passing, that document would be submitted to the probate court, and they would say, yes, this is the will, we're going to follow it, etc., etc. If you have it on a napkin, and it doesn't have those sorts of formalities, then it's totally up to the judge. They're not going to say it's a will, but they might say, maybe this evidence is some sort of intent. And so then they might figure out a way to kind of enforce that. If it's contested, they probably won't, right? So if your heirs are saying no, then they probably won't follow it. But yeah, so there are some formalities. In jurisdictions where holographic wills are not legal, typically you need to have a written will, typed or handwritten is fine. It has to be dated. It has to say, this is my last will and testament. I'm of sound mind, blah, blah, blah. I'm not being coerced. This is what I want to have happen. Like, this is what I want to have happen to my property. Blah, 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 blah. Just a little tidbit. You always want to have a clause at the end that says, and anything I didn't leave, anything that I failed to mention, we call this a residual clause. So everything that I didn't mention, like my furniture, or like, whatever else, my remote control. People get crazy about property when someone passes. So anything that I didn't mention here is given to X, Y, and Z people. You typically have to have it signed, you typically have to have it notarized, and you typically have to have 2 to 3 witnesses. Now the witnesses don't typically have to know and read your will. It's so weird, you guys. The law is so weird in so many ways. They have to know that what they're watching you sign is your will. So you have to say, hey, will you guys witness me? I'm going to sign my will. And then you sign it, and then they sign as witnesses. But you don't have to read my will. I don't have to let you read it. You just have to know that I am in fact signing the will.
So, and you would leave copies of this will with everyone who would be affected by it, but you don't have to register it?
In most jurisdictions, you don't have to register it, but I can't speak for here because I'm not licensed here. You can register it in some jurisdictions if you choose to. This is another reason why I tell lawyers and other people never, never, never put key material into a will. The reason is because a will after your passing will become a public record. Meaning that if you put your passphrase or your seed words into your will document itself, you're going to have a race, and your heirs are probably going to lose. Because I guarantee you that there is a bot right now that is trolling public records for anything that looks like Bitcoin keys or Ethereum keys, right? And so you don't want to put your heirs in that position. So you need to remember that these are public records, so you don't want to put that in the document itself. You can just reference it. You can just say, hey, I have cryptocurrency. It's referenced in this document over here. Does that answer your question? Yeah.
Can you incorporate businesses, other businesses, LLCs inside of that?
You absolutely.
And how much? And what do you charge for that?
Who?
What do you your company? You write these living trusts and wills and stuff.
Oh no.
Oh, you don't write them?
No, I'm a liaison between legal and tech. So what I do is I work with your lawyer, and I teach them what they need to understand about key security and management. So I work with them, and I work with you to develop an access plan. And the reason that I don't do this is because every single state is unique. Inheritance law, like family law, like marriage and divorce and all of that, is state by state. I'm only licensed in Michigan and Illinois, so I'm not licensed to practice here, so I can't do that. You absolutely 100% would include, if you have a business, you would want to include that in your will. It's super important. I'm also a big fan of having, if you have more than one party in your LLC, like if you have 2 people who are co-owners, you want to have a buy-sell in there. because if you don't have a buy-sell in your operating agreement, what will happen is, if you and I have a business together and I pass, guess who your new partners are?
Kids.
My family! Lucky you!
Depending on whether it's a joint venture or a,
It depends on the operating agreement. It depends
Yeah, I was
on
gonna say
the...
operating agreement. You can put that in there too.
Absolutely, super
Yeah.
easy, and it should have it in there, but
Mhm.
sometimes they don't, right? So you want to, like, as you're doing your inheritance planning, like, these are the kind of things that you want to think about. So if you have businesses, you'll definitely want to do some sort of planning. Yeah.
So I guess amnesia is probably a big issue. Do you deal with people getting old and forgetting, and like maybe your family should be able to access it while you're still alive? If you can't access it and don't even remember you had it, or it's a touchy issue, right?
I mean, yeah, I do have clients that have memory issues that are kind of dealing with those sorts of things, and their plans are obviously very different than someone who's not dealing with memory issues. But at the end of the day, the reason that they're different is because they need more easy access, right? Your heirs are still going to need the same amount of access as you will. It's just where you store those access pieces. How far away are they? How difficult are they to get? That sort of stuff. Does that answer your question? Ish?
I guess he just made me think of something. What about power of attorney and that issue where, let's say you end up 40 years, get dementia or Alzheimer's, like, is there something that needs to be done more extra for that?
Yeah, I mean, so in my world, so this is all brand new. This is one of the reasons why I love this industry is because, like, as I said at the beginning, nobody really knows. We're kind of making everything up. We're using, best practices, and we're using, like, okay, how do laws in other areas apply? So in my world, this is just another financial asset. So your financial power of attorney would be the same way. If you have a feeling about whether or not you want your crypto used for your care, you could make that known. Typically, your family is, at least in my experience with families, they will use whatever assets are available to them to take the best care of you that they can. Most families are not interested in kind of, secreting the money. But again, if you have that kind of family, or if that's something that you're worried about, people do set up. This is true, though. There are people who have these families, really. Mostly they come to us as lawyers because they're like, I have a shitty family, and like, I need to do something. You can set up a trust that will, so how many of you guys are super familiar with trusts and like, okay. So not everyone. So what a trust is a trust is effectively like a corporation, except instead of having a purpose to do a business, the purpose is to manage assets. And so trusts come in lots of different flavors. Some of them are for asset protection, some of them are for creditor protection, some of them are for long-term care, some of them are for charitable purposes. There's lots of different things. But at the end of the day, the reason that this matters for inheritance planning is because if you put your assets in a trust and you die, nothing happens effectively. The trust continues, just like a business continues if the principal dies, right? If the CEO of Coca-Cola passes, Coca-Cola doesn't close, right? Coca-Cola keeps going. Same way here. So everything in the trust continues to go. Now the assets might go to a different person or they might be managed by a different person, but the trust itself continues to exist. And so that's a planning mechanism that people use in order to kind of, if they have long-term care issues, where they'll put their money in the trust that is for us.
And just as far as for like, I guess, I don't know, maybe abatements or taxes, you don't have to go through all of those types of things when you leave it to someone. So yeah, trust is. What did you think better, an irrevocable trust or a living trust?
Oh, I don't know. I mean, I don't know the law here, so I can't really, give advice on that. Here's what I'll say about irrevocable trusts. If you've lived for a few decades, you will know that people change, and situations change, and relationships change. And the people who you are very, very close to now may not be the same people who you're very close to later. Drugs happen. Bad partner choices happen where people kind of fall off the rails. A mental illness happens. A lot of different things happen. And the irrevocable trust that I've seen, an irrevocable trust is where you put your money, your assets in, and then you have no control over them. You cannot touch them. Only the typically only the beneficiaries can make a change to the ultimate trust, and the trustee can decide what's going to happen with the assets. If you have a super stable family, like a lot of people use irrevocable trust if they're giving to their children.
Yeah.
Like that's something that like, okay, they're always going to be my kids. I want them to have the money. Like this is good. That's one of the most common scenarios that people use this in. The reason that they use it is because it's not their asset and they can protect their creditors, and there are lots of pluses. These are really nuanced questions that you have to like look at the pluses and minuses with a lawyer, with a qualified lawyer who can actually tell you not only legally what is going to happen when you pass, but what are the tax implications now. So you need someone who can actually do tax planning as well as estate planning, because you need to understand right now, what's it going to cost me? What's it likely going to cost my heirs? How is this actually going to play out? And trusts aren't free. So normally you have to, unless you're the trustee and you're managing it yourself, in a revocable trust you can't do that. So you actually have to pay a trustee. Trusts also have to pay income tax. So there's a lot of things, right? They don't make it easy, friends. They don't make tax planning easy. That's why everyone doesn't do it, right? Only the rich.
They come in and take what they want.
I mean, so if you're, if these sorts of issues are important to you, then it would probably be a good idea for you to find a good tax lawyer, a good inheritance, estate planning lawyer who can help you.
Thank you.
You're welcome.
There's really a comment on two questions back, but where I started on my will was with LegalZoom.
Oh yeah.
And it produced, to answer that question, it produces 3 documents. It produces the living will, the last will and testament, and the power of attorney. And then separately, which my parents did, you can also do a trust through them and all that. But that's where I started. The one downside I found with it, you can't change a word in it and refile it back with LegalZoom.
Oh really?
Yeah. Yeah, you can't. I wanted to just make, because when it's listing number of errors, for instance.
Right.
Well, I had 3 listed, and I wanted to add it a 4th. And there was no template, no selection to put that in, even though you're duplicating the exact same text with a different name.
Oh wow.
It wouldn't let you put, and I specifically wrote to them, and I said, okay, well, I have to do this. And all they could do is say, oh, well, they can give me the Word document so I can go and edit it. But now I have to go take it to a lawyer or something like that.
Right. Right. Well, because if you make even the tiniest little change, then it's the practice of law, and LegalZoom has had a lot of problems with lawsuits from bar associations. We're trying to get them to go out of business. I hope they don't succeed. I think it's completely ridiculous that you can't download a legal form. You should not have to hire a lawyer for that.
I got one more question. What happens, this may be totally out of scope. Let's say I marry my half-Canadian girlfriend. We go move to Canada and become Canadian citizens. What happens to our United States family?
So typically how it works is everything except real property that is located in a specific place. Real property meaning real estate, a building, a piece of land, something like that. Typically, the inheritance laws where you live apply. Meaning that if you move to Canada, you move to Ontario, whatever, you would need to find out what the laws are in that jurisdiction. You need to know what the intestacy laws are in that jurisdiction, right? And then you need to know what the wills law are in that jurisdiction. And that's how your assets are going to be distributed unless you do a trust. So if you already put your assets in the trust, right, like a company, you move to Canada, it doesn't matter, because the trust is governed under the rules that you set it up in, right? Typically, again, this is like not legal advice, I should put the like disclaimer earlier, but typically this is how it works. So if you don't write a will, then things get a little more squirrely, right? And if your family is here, they would typically be entitled to the same thing. Like most jurisdictions recognize blood, right? Like some jurisdictions don't recognize females. So hopefully you're not moving to that jurisdiction. But so like they do squirrely things. It's important to know like where you reside, wherever your legal residence is. Those are the laws that are typically going to apply. That said, if there's a building, the local court does not give up jurisdiction over that local building. So what typically happens is if you've moved to Canada, there will be a probate estate opened in Canada, and then there will be another one opened here solely for the purpose of distributing that real estate in conjunction with that estate. Yeah.
Now, following up on that point, though, if, let's say, you have your trust or whatever goes to probate in a state like South Dakota or Ohio that doesn't have inheritance tax, but your the people that inherit live in other states, live in Pennsylvania or places that do have inheritance tax. To them,
that's a really nuanced question you're asking. Yeah, I can't answer that because it all depends on the language in the state law. You can get into some squirrely situations like that. For those sorts of questions, you would definitely need to consult a lawyer in both jurisdictions, unfortunately.
If you're planning to pay tax.
well, actually, she makes a very compelling case in the book that you kind of went over pretty quickly, but make a very compelling case for why you actually do expose, but when it finally goes to probate, that you do expose the actual amount that you have at that point.
Yeah.
Because you're getting, it's not yourself that you're getting in trouble, it's other people you're getting in trouble.
Right. Well, and there's a lot of pressure at that point. Your family is grieving, right? They're going to want to do what you wanted them to do, right? So they're going to feel this compulsion to do what you set out. I'm no fan of taxes, okay? I'm not like, oh yeah, everybody should pay the taxes. Like, I'm not a fan of war, I'm not a fan of funding war, any of that. But I'm also not a fan of your heirs going to prison.